So it might be the case that the Electoral Commission has acted in a biased manner and have done this for partisan reasons, but we don't have enough evidence to determine that.
South Africa's Constitutional Court has handed down judgment with regards to the IEC matter. This pertains to the local government elections and the IEC's original application to have these elections postponed. This application was denied, but a second component to this case regarding the candidate nomination lists was also considered. Joining me to discuss these two components is Advocate Mark Oppenheimer. He is with the Johannesburg Bar and also represented the IRR as an amicus in this case. He's also the host of a new podcast, which is called Constitutional Landmarks, which we'll link to below. Mark Oppenheimer, could you give our listeners just an overview of the details of this case and the implications?
Yes, so if we start with the IEC's application, it came to court and it said, we cannot have a free and fair election by the 27th of October. We need a postponement, and we want a postponement until February, and we will submit to the court's guidance on this front, and we will keep you updated about the COVID situation, and we don't think it's possible for us to produce this election. And the court dismissed their case. The court said, we don't think that COVID will stand in the way of an election. Deputy Chief Justice Zondo said elections have been run all around the world, and if you look at where they were run, where proper protocols are in place, there were no spikes in COVID, and so you must run the election, and there's a constitutional requirement that you must run it within a certain period of time. So the case was dismissed. What happened was that the court produced its order, in other words, what must happen, before it produced its reasons. And so it said there must be an election. And one of the questions that was before it was brought by the EFF. The EFF had said, look, if you're not going to grant the postponement, then will you reopen the candidates' nomination lists? So this is a municipal election, which means you've got ward councillors and PR councillors running in 4,700 odd elections throughout the country. And every party is putting forward candidates, and they have their own internal struggles about which candidates will be running and where they go. And it has to be done by a certain period of time, which was the 23rd of August. And the Electoral Commission specifically opposed that relief. And they said, look, if we are asked to run the election by the 27th of October, it will not be possible for us to reopen candidate nominations. Elections don't just happen on one day, they're a process. And so we have to certify a number of steps. We have to make sure that the voters' roll is correct, that people that have put their names forward on candidates are actually entitled to run. We have to give parties the opportunity to inspect it, and we have to go and print off 78 million ballots across the country. So we cannot open candidate registrations. We've already given people an extra chance. It was going to be the 16th of August, and we've pushed it to the 23rd. Enough is enough. The court looked at the relief and dismissed it. Then the judgment comes out, and the IEC say, we're going to reopen candidate nominations, to a lot of people's surprise. And they say, well, the reason why we're doing it is because the court authorizes it. The court order says the Electoral Commission is entitled to amend the election timetable if it is reasonably necessary. And they say, well, it's reasonably necessary to add in candidates. So the DA took them to court and said, you can't do this. It appears partisan to us. When this kind of issue has cropped up before, when the IFP didn't get the candidate list right and the NFP didn't pay the deposits that they're supposed to pay, the Electoral Commission said deadlines are deadlines, and we have to treat everyone fairly and equally, and you didn't meet the thresholds, so you don't get to run wherever they didn't put candidates forward. And this was endorsed by the Constitutional Court in those cases. The IEC say, well, we definitely weren't acting in a biased way. The ANC say, please, please, please help us, on our knees help us, because we haven't paid our staff for the last 3 months, and they're very angry with us because all the money that we were supposed to pay over to SARS that we've been deducting from their salaries for a while, 80 million bucks worth, we actually kept it and spent it, and so we didn't pay them either. And they went on a go slow for 3 months, and they refused to register our candidates. There's about 537 people across the country we didn't run, and we didn't run a single PR candidate in the whole of the Western Cape, and there's 30 municipalities which we currently run, and we didn't run candidates there either, and we're going to auto lose. So please, 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 please help us.
Enjoying this analysis? Click here to sign up for our 30-day free trial for more content from the CIA.
And the IC said, well, of course, we didn't take that into account. We just did what was free and fair. And so the court considers this question, and it considers a range of challenges. First of all, it says, look, if you read our order, it's very clear. You're allowed to do what's necessary for voter registration. So our order, without a doubt, does not grant you the power to reopen candidates. Not okay. And that's what the IEC told everyone they were doing it from the base of the order. They then said, well, but the election's been postponed, and the Act says that if we postpone an election, then we're allowed to amend the timetable. And the court said, there's no postponement. We specifically denied your postponement. And the fact that the election date has changed because Lamini Zuma had proclaimed the 27th of October and is now intending on re-proclaiming on the 1st of November is not a postponement. The first one was a nullity. She'd infringed on the rights of all these people who weren't able to register to vote. So it's as if it never happened. Not a postponement. You don't get to reopen the candidate list for that reason. But Section 11(2)(a) says that if the Electoral Commission determines that it is necessary to amend the timetable for the freeness and fairness of the election, then it has the power. And here the court says, look, the Electoral Commission told us before that it was impossible. They're now telling us that it is possible, that they can do this Herculean effort. And we don't really have much choice but to trust them, because we're bound by what's called the Plaskon-Evans rules, which is that when you're looking at the evidence on paper, you basically believe the respondent, and whatever's not denied by the respondent, you believe the applicant. So it might be the case that the Electoral Commission has acted in a biased manner and have done this for partisan reasons, but we don't have enough evidence to determine that. If that were to come out later, the DA are very welcome to run such a challenge and attack the constitutionality of these elections. But at the moment, we can't make that determination, and we have no choice really but to trust that the IEC acted with bona fides. And so they've said that power is preserved. And on that basis, the IEC have said that they're going to reopen candidate lists.
So, Mark, you were representing the Institute of Race Relations as an amicus in this matter. What were some of the arguments that you put before the court?
Well, we said that there are only two places in which the IEC could find the power. The first is in the order, and we said the order doesn't allow it. And then we said the second could be in the Act. And we said that there is no postponement, and so there's no power there. And on the freeness and fairness, we said, look, there's good reason to believe that it would undermine freeness and fairness if you were to allow candidate registration, given the IEC's own evidence in the original litigation, where they said, look, there's only so much time available to you, and freeness and fairness requires that we're able to go through the certification process properly to ensure that you don't have the wrong candidates running, that we have enough time to print ballots, that this would undermine it. We also said that there's another way to solve the problem. The Electoral Commission's claim was, I said, the people who are being denied their rights are those people who weren't registered and wanted to run as candidates. And it's really for their benefit that we want to reopen. And the DA said, well, if it's that narrow class of people, then just open it up for them. And the IEC's response, they said, well, that's a little difficult. It's going to take us like 3 weeks to update our systems so that we can identify that. And we don't really think we can do that in time. So we're just going to have a total free-for-all and open up to everyone. We said, look, you don't even need to do that. You have a closed list of about 1,300 people who've put their names forward as candidates who are not registered. Now, there's an interesting feature of our law, which is that in order to put your name on the list, you don't have to be registered. But the IEC has the power to remove your name from the list of candidates if you are not registered. And so we said it's simple. Wait for the registration weekend to occur. After that's happened, check that list of people. Everyone who is registered, you keep on the list, and everyone who's not registered, you remove. You don't have to reopen candidates at all. You don't have to have another separate process. Your legislative powers are already in place. The court doesn't deal with this argument, which is a pity. It would be nice to have had some engagement on the question. The other thing we said was, once the 11(3) of the Act says you must perform the acts that are required by your election timetable before the time has expired. And our interpretation of that means once a deadline has passed, you cannot amend the timetable. So the deadline for candidate registration was the 23rd of August. That deadline has passed. And we said, well, 11(3) means you can't amend, you can't change. The deadline's passed, done. The ConCourt disagreed and said, well, we think that even if the deadline is passed, you can't perform the act unless you amend. And if you amend, then the timetable is fixed, in which case you're not doing it at the wrong time because you changed the time requirement. So those are the kinds of arguments that the IRR put forward. And the majority of the arguments the IRR put forward were accepted by the court. And it's really the small sliver which the Electoral Commission were able to get through with the relief that they wanted.
Well, Mark, this has certainly been a very interesting and unusual election, and I think it's been fascinating to watch some of the litigation around that. I mentioned in the introduction that you are hosting a new podcast. Do you want to, as a final word, just give us a brief description of what you are focusing on in that podcast?
Yeah, so the show is called Constitutional Landmarks. We're on YouTube and on your favorite podcasting app. And basically, it's an eyewitness account of the main cases the Constitutional Court has dealt with in its history. So the first episode is on two pieces of litigation involving President Zuma. So the first is on the contempt case and his application to have that contempt set aside. And so there's original audio from those judgments. And then I spend a lot of time on the Nkandla case, which was the first time that the Constitutional Court held the president to account and made him pay back some of the money that had been spent on his palace. And I go and interview Vim Trengrove and Gilbert Marcus, who both participated in that case. And we then also listen to the judgment from that. And you have Chief Justice Mogoeng, with these resounding words saying that the sword of justice will chop off the rotting head of impunity. That's the first episode. We will be doing a range of episodes. It's a limited series. The next one will be on the death penalty. We have one on gay marriage. I'll be talking to Albie Sachs, Johan Krickler, Yvonne Mahoro, and some other advocates that were involved in really the greatest cases that our country has ever seen.
Mark Oppenheimer, thank you very much for joining us on the CRA channel. We'll put a link to your podcast in the description below, as well as in the pinned comment. My name is David Ansara. Until next time, take care.